Hi, this is Josh Blackman. I am the president of the Harlan Institute, and it's my honor to welcome you to the 2020 Harlan Institute Ashbrook Virtual Supreme Court competition. Today, we are arguing the case of Torres versus Madrid. We have two wonderful teams today. For petitioners, we have team 8017, Charlotte Ortiz and Cora Hughes. And for respondents, we have teams 8023, Semira Morgan and Katelayn Vault. If there are no other questions, we'll begin. Petitioners, you have 10 minutes to start.
May it please the court. My name is Cora Hughes, and alongside my co-counsel, Charlotte Ortiz, we represent the petitioner in today's case. The question presented is whether physical force is needed, it needs to be successful in order for there to be a seizure under the Fourth Amendment.
We will first address how there was an intrusion of the body, therefore triggering the Fourth Amendment, by using common law. We will then argue that the respondents did seize the petitioner, even if it was unsuccessful, using United States v. Hodari. Lastly, we will present the precedent being set.
Will the court benefit from a brief recitation of the facts?
Yes, please.
Okay, on July 15, 2014, two New Mexico police officers, Janice Madrid and Richard Williamson, who are the respondents in today's case, went in the early morning to an apartment complex to arrest a woman that they had a warrant for. They saw a separate woman, Roxanne Torres, the petitioner in today's case, standing near her car.
Torres at the time was under the influence of methamphetamine and did not know that the two people approaching her were police officers. When Torres put her car in drive, trying to escape who she thought were carjackers, the respondents shot at Torres. 2 bullets struck her at the scene, but she continued to drive away. Torres then lost control of her car and decided to carjack another car to go to the hospital for her wounds, and she was arrested later the next day.
For there to be a true violation of the Fourth Amendment, there needs to be an intrusion of the person. It is crucial that we protect personal security as agreed in Terry v. Ohio. In previous cases, the court has noted what is an intrusion in the body and what isn't. In Semira v. California, it is said that an invasive surgery may raise privacy concerns weighty enough for the search to require a warrant. But a buccal swab, which involves a brief and minimal intrusion with virtually no risk, trauma, or pain, does not increase the suspicion, as it is a procedure.
The buccal swab is a process used to
If I could interrupt, Counselor, you mentioned the Hodari case. I think it's California versus Hodari. Does that case decide this case? In other words, do we already have a holding? Do we have anything left to do, or does Hodari resolve this case for us?
Can you repeat the question, please?
Sure. Did Hodari decide this case? In other words, is the rule from Hodari settle what is before us today?
Technically, no, but we can still use language. I say that because this case is a case of first impression, so there isn't anything previously that will explicitly decide this case.
Well, is there anything from Hodari that helps your case?
From Hodari, Hodari states that an arrest requires either physical force or where that is absent submission to the assertion of authority. The physical impact must be intentional and must be designed to restrain movement, as we have here. So we can use that language to help decide this case, but as I mentioned before, Hodari doesn't explicitly decide the case for us.
All right. Are there any other common law precedents, perhaps from England, that might inform our decision today?
Well, Your Honor, there are no cases specifically that go over the issue, but we can use case law to help with the common law definition.
Okay. Well, what cases do you want to discuss?
Nickel v. Darley, it states that with the slightest touch, that constitutes an arrest, which cannot be invalidated by the officer's inability to detain the suspect. So that goes towards our case as well, as this physical approach wasn't necessarily successful.
Okay, you can proceed, or if my other colleagues have any questions.
I have a question. So just looking at the word seize, if I were to shoot a document that wouldn't be a seizure of the document. I wouldn't be taking possession of that document. But with shooting a person, that's supposed to be a seizure. Should there be a different rule for documents, papers, than there are for people? And if so, why?
Well, Your Honor, if we look at the totality of the circumstances, we can say that a paper is probably not as severe as a person. And the Fourth Amendment is meant to protect persons and places and things. But in this case, I think it's more severe a person than it is a paper, if that makes sense. And I just think that although, you know, it's right, there needs to, I mean, there is a seizure if you a paper. But when we look at the intent, I think the gravity is so much greater with a person than it is a paper.
Thank you.
All right, you may proceed, Counselor.
So the definition of an intrusion can be analyzed by the unanimously adopted Virginia Declaration of Rights, written by George Mason, which states to seize any person or persons not named or whose offense is not particularly described and supported by evidence are grievous and suppressive and ought not to be granted.
To not have evidence to support this violation of the Fourth Amendment is an intrusion. If the court were to find that this fact pattern is not protected under the Fourth Amendment, is diminishing what James Otis declared against writs of assistance, the power that places liberty of every man in the hands of a petty officer.
In regards to a seizure, application of force with the intent to stop, regardless of whether that attempt is successful, is a seizure. There are two elements when deciding what constitutes a seizure. One is by means of show of authority, and the second is by the application that terminates or restrains someone's freedom of movement with the intent to stop, as set by Terry v. Ohio.
Well, let me ask you a question if I can, Counselor. What happens if a police officer taps a suspect on the shoulder? Is that a seizure?
No. And I say that because we have to look through the lens of a reasonable man, the reasonable man standard. A simple tap on the shoulder is not enough because it's not meant to restrain someone. Now,
What if the police officer, sorry to interrupt, what if the police officer taps someone on the shoulder with an intent to detain them? It's like, you know, he's like, excuse me, and he taps them. Is that enough?
Right. Right, with the intent, it certainly constitutes a seizure, but again, it's not, that's show of authority. This case is—
Not show of authority, he taps and says, excuse me. That's all he says. He doesn't identify as police, he just taps and says, excuse me.
If he taps and says, excuse me, there still isn't any, and there's no clear intent to restrain someone.
What if the suspect understands there's an intent? What if the suspect says, "Oh wow, I'm scared. Some guy just tapped me the shoulder. I'm not going to run away." Does that make it a seizure?
No, Your Honor, because there needs to be enough force present to create a reasonable suspicion of success of seizing the person.
Okay. All right, you can proceed, counsel.
Physical force is present in this fact pattern, but does not show that the respondents terminated the movement of the petitioner. The facts do, however, present a successful restraint of movement. The moment Torres was shot was the moment she was seized. It is crucial that the court follows language of case law.
As it is said in Michigan v. Summers, that a seizure of a person within the meaning of the Fourth Amendment is a meaningful interference. And with the individual, meaningful interference, however brief, with an individual's freedom of movement. The seizure itself only lasts a period of where the application is being applied. As Hidari says when citing Thompson v. Whitman, a seizure is a single act and not a continuous fact.
The period where the
So to clarify, counsel, you're arguing that the seizure in this case took place over the span of a millisecond as the bullets entered Ms. Torres's body, but not while they were in her body while she was driving away.
Right. This fact pattern is really different and special. And we can see that it didn't restrain her movement as she drove 75 miles away from the site. But as I mentioned in that Thomas V. Webson says, is that it's a single act and not a continuous fact. If you put someone in a chokehold, for example, while that person's in a chokehold, they're seized. But if you let that person go, they're not seized anymore.
So in this
you're not
case,
restraining their movement anymore.
So in this case, I guess I'm wondering, for how long was she seized? Was she seized just as she was being shot, or while the bullets were in her body?
Right. The period that there was an invasion of the body, the moment that the bullets hit her body and went into her body is the moment she was seized. And it doesn't matter if it was, milliseconds, she still was seized at that moment.
So she wasn't seized while she was driving.
I'm sorry to interrupt, but we're just about out of time, so I do want to make sure we're fair to the other team. But thank you, Counselor. Justice Herbert is always eager to go, but we'll come back to you in rebuttal time. Thank you. All right, can the respondents come up, please? And you'll have 15 minutes.
May it please the court. My name is Semira Morgan.
And I am Caitlin Balt.
And we represent the respondent in today's case. The issue brought before the court is whether an unsuccessful attempt to detain a suspect by use of physical force qualifies as a seizure.
We will be arguing that in order for a seizure to occur, the physical force must be successful. We will first argue that this court has defined a seizure to be a submission to authority or the use of physical force that restrains the person. Next, the expanding the Fourth Amendment to include unsuccessful seizures will overwork both the courts and police officers. Lastly, the petitioner's analysis of Hudari does not apply to our case as well as common law.
The Fourth Amendment states the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. This court has established the definition of a seizure and determined it to be when government actors have, by means of physical force or show of authority, in some way restrained the liberty of a citizen. This was held in Terry v. Ohio and Broward v. County of Inyo. In order for there to be a seizure by show of authority, the person must submit to that authority as held in Brennan v. California. In today's case, the petitioner did not submit to the officer's authority. Torres instead drove away after being shot twice by the officers. There was no actual submission by the petitioner to the officers.
Furthermore, she was not seized because the officers were not able to restrain her. In Terry v. Ohio, the court stated it must be recognized that whenever a police officer accosts an individual and restrains his freedom to walk away, he is, quote, seized, that person. While the officers used physical force by shooting at the petitioner, her freedom was not restrained as she was able to continue to drive, steal a car, and proceed to drive another 75 miles. Broward v. Inyo also determined that there must be intentional governmental termination of movement and physical control of the person. The officers intended to terminate her movement, but were ultimately unsuccessful.
If I could just jump with the question, your friends on the other side said this is a case of first impression. How do you think Hodari D affects the outcome of the decision? Are we governed by Hodari D?
Can you repeat the question?
Is this case governed? In other words, does Hodari D decide this case? Are we bound by Hodari D?
Hudari, in the conclusion, was concluded that there must be a submission to authority for Hudari to apply to this case, but in this case, there was no submission to authority as the petitioner was able to drive another 75 miles and was able to walk away and was not obtained by police officers.
Yeah, but let me ask you a question, right? Maybe you're Superwoman, right? You're Wonder Woman, and you get shot at 13 times and you keep going. But most people aren't that strong, right? If you shoot me once, I'm down for the count. I'm done, right? I'm on the floor. Maybe Ryan and Curtis are stronger than me, but I'm out, right? How can it be that if you shoot someone 13 times and they magically, maybe she was tripping, right? But she keeps going. How can that not be a seizure?
In order for it to be classified as a seizure, yes, there was physical force used. The amount of physical force not necessarily being as you could say, relevant, but there was physical force used. But since the petitioner was not, the police officers were unsuccessful, as the petitioner was still able to escape, which does not constitute as a seizure. Therefore, it's not a seizure because she was not able to be attained by police officers, regardless of the amount of bullets used and regardless of the damages done to the petitioner.
Okay.
What if the police had killed her though, and she was never taken into custody? Would that have been a seizure?
If the police killed the petitioner and she was never taken into custody, it would not constitute, I mean, it would constitute as a seizure because she would be unable to escape, basically.
The court should uphold the previous decisions that determined a seizure
I
to
have a
be.
question. The police clearly intended to seize her, and they took drastic steps to seize her. Why isn't that intent enough? Why doesn't the fact they intended to seize her clinch it?
Well, Your Honor, and also with the intention, their seizure must be successful. This court has held that a seizure occurs when they're taken possession or restrain the liberty of their movement. And also it aligns with the public's definition of the meaning. Published in 1788 to the farmers and planters of Maryland, which was written by members of the public, it stated that find any the least article that you cannot prove the duty to be paid on, seize it and carry it away with them. It can be implied that in order for a seizure to occur, there must be physical control of the person or object, because in order for something to be carried away, there must be control. This aligns with the common public's definition of seizure, along with several cases that come from this court. For example, the J. Bouvier Law Dictionary, published in 1856, states that the definition of a seizure as taking possession. Furthermore, Webster, an American Dictionary of the English Language, published in 1828, defines seizure as taking possession as well. And also stated in California v. Hidari in maritime law, a ship still fleeing, even though under attack, would not be considered seizure as a war prize. The common public definition.
Right, that was on mute. If I could just interrupt briefly, very good. You saw it in my mouth, but there was no words coming out, so good job. Let's just be real here, right? You can read me all these dictionaries from 300 years ago, right? All these old cases, but the cop shot this woman 13 times. How is that not a seizure? I mean, I'm really struggling with your position. How is this? Don't you agree this was an unreasonable act? I mean, they shot her 13 times.
Well, Your Honor, we're not here to discuss the reasonableness of her, and they only shot her twice, I believe, and
two bullets hit her. So I guess maybe their aim was better. She maybe would have gotten a better lawsuit, right?
Yeah. She was only hit by 2 bullets, Your Honor. And if you want to hold the police responsible, you shouldn't hold it responsible under the Fourth Amendment as the seizure. If the states want to take accountability for the officers, then the states can't do that. But in this case, it's not a seizure because there was no actual physical.
What other way can we hold them accountable if we don't have a Fourth Amendment suit? What other options does the plaintiff have in this case?
Well, Your Honor, if the states want to waive sovereign immunity, they can. If the federal government wants to waive sovereign immunity, they can. But we can't twist the word of a seizure to give back to the petitioner. The word seizure has always been to take control, to have physical control. The common public's definition has remained consistent that in order for there to be a seizure, an officer must take control of the person.
If this court were to decide to expand the meaning of a seizure to include failed attempts, the court would have to sort through all cases that involved failed use of physical force along with actual seizures. This court would be unnecessarily expanding the Fourth Amendment. For instance, if an officer attempted to seize a suspect by grabbing their arm, but the suspect was able to get away, under the petitioner's rule, this would qualify as a seizure and would have to be reviewed if the question of reasonableness arose. This rule would force courts to go over this failed seizure when the rule is simply not necessary or productive. Furthermore, this rule would make the jobs of police officers quite challenging. Officers would be under constant scrutiny on how they attempt a seizure, a suspect, which would ultimately lead to them changing the way they handle their jobs. Officers would be hesitant to use physical force to seize a person in fear that even if the attempt failed, the suspect could possibly press charges.
Well, counsel, let me give you a hypothetical, right? Let's say instead of shooting the plaintiff here, the police tried a different tactic. They called ahead to their highway patrol friend and said, look, we know she's going down this highway at 75 miles an hour. I want you to put up a roadblock, put up a cement barricade in the middle of the highway. Okay. They put up this barricade. She doesn't see it. She slams into the wall and crashes her car and wrecks her car. Is that a seizure?
Although they used a different tactic, if the officers are able to obtain the petitioner physically and they are able to take her into custody, it would account as a seizure despite the method.
Okay, so again, she slammed. Okay, so I don't think you answered my question exactly, but I'll ask it again. She slams her car into the cement barricade. Those are the facts I give you. Does she have a seizure?
Yes, as the officer's intent was to seize, and the officer's intent was to obtain the petitioner, then yes, it would be a seizure.
All right, now let me just twist the hypo a little bit further. Okay, so she slams her car into the cement barricade. Then somehow, by the grace of God, she gets up and starts running on foot. I mean, this is like Wonder Woman here, right? An Incredible Hulk, right? Nothing's going to stop her, right? She keeps running. Has she been seized if she got out of her car and starts running down the highway?
No, she is not. She is, although the intent of the officers with the barricade was to physically obtain her, and the suspect, like in this situation, she was able to get away with the car and drive 75 miles. She was not physically obtained by the officers despite their intent.
So, Katelayn, just one more question for you, ma'am. At what point then is the seizure? Is it when she slammed her car into the wall, or when it became clear she couldn't escape and run another, mile down the road? When do we determine if there was a seizure or not?
We determined it's a seizure when if the suspect were to run out of the car, then she would not be submitting to authority. But when the petitioner slammed into the barricade walls and was unable to move, it then became a seizure, as officers could now physically obtain her.
And then maybe I'll ask a question for your partner, Semira. Isn't this a weird rule that a person's rewarded for being weak? That, if you have a weak person who goes down right away, they were under arrest, they were under submission, they can sue. But if you have the Incredible Hulk running around there, Thor, right? They're not able to stop. I mean, isn't that like a weird rule?
No, Your Honor, it's not a weird rule. If a person is able to move and their liberty hasn't been restrained, they haven't been seized. And this has been the common definition, and it has been ruled on in several cases by this court. The weirder rule would be if a person uses physical force and the person is able to get away. This would open up officers to a lot of lawsuits, and it would also make them scared to do their job correctly if they'd be under constant scrutiny. In this case, our rule is the simple rule that works for everyone.
Okay, very good. All right, counsel, you may proceed.
If changes are made to the Fourth Amendment, this will result in officers not effectively doing their jobs correctly and can even discourage others from joining the force. This also puts officers at risk when it comes to a pursuit. Pursuits are often dangerous, and if officers become hesitant, that could result in a life or death situation. As stated in Hudari, street pursuits always place the public at some risk. The petitioner's rule would not only overwork our justice systems with complaints about failed seizures, but it would also negatively affect how police officers handle their jobs. It would also put the public and the police officer in danger.
The petitioner's reliance on common law cited in California v. Hudari is not binding to this court. As held in Tennessee v. Gardner, has not simply frozen into constitutional law those law enforcement practices that existed at the time of the Fourth Amendment's passage. While this court does look at common law for guidance, it does not mean this court has to follow it exactly.
Well,
Furthermore,
what gives us the license to deviate from the common law, though? I mean, aren't we all originalists here? Don't we have to follow the original meaning of the Constitution? Couldn't we? I mean, why are we so wedded to the past? You keep saying these old dictionaries, these old cases from England. We're a different country today.
Well, Your Honor, the meaning is still present. As recent as 2007 in Brennan v. California, the court ruled that the seizure has to restrain their liberty. Furthermore, in Anderson v. Creighton, the court said that common law definitions do not necessarily control the meaning of the terms in modern trade laws. This court has made it clear through several cases that common law is not definitive. It is merely a guide for this court to use and should not overrule this court's decision in Brower, Brennan, and Terry. Brower, which was decided in 2007, written after Hodari, shows that this court has consistently held that a seizure must be successful, which disagrees with the petitioner's common law definition.
Lastly, Hodari does not apply to our case and should not be binding on your decision. Hodari heavily relies on common law and, as is stated earlier, is not definitive. Hodari also does not have similar fact pattern in today's case. In Hodari, there was no actual physical force that occurred when the seizure took place. Hodari claimed that he was seized when he saw the officer begin running towards him. The question was, did the seizure occur at the time the drugs were thrown, which occurred before Hodari was tackled? In our case, the physical force actually occurred when the officer shot at the petitioner. Furthermore, Hodari is not a reliable case when it comes to the definition of the seizure. In the majority opinion, the court using common law claims that even an unsuccessful seizure is still considered a seizure. The court then states in footnote 2 that, and quote, but neither usage nor common law tradition makes an attempted seizure a seizure. The court acknowledges that the common public's definition along with the law does not acknowledge an attempted seizure an actual seizure. The petitioner's reliance on this case fails to acknowledge this clarification. Hodari, who heavily relies on common law for its ruling, does not mean that the court has to follow its ruling. Common law is a mere guidance, not definition.
Counselor, wasn't Hodari a unanimous opinion?
Yes.
And what about Brower v. Inyo County? Isn't that binding on us too?
Yes, Brower v. Inyo is binding on this case.
And that was a 9-0 decision too, wasn't it?
Yes, Your Honor.
So and they were both majority opinions were by Scalia, right? So
Yes.
so how does that seems like it's a pretty coherent view, and maybe even if some of the language in Hodari's dicta, the court's definitely trending towards the conclusions in Hodari. How should that affect the way we think about this case?
Well, even in the conclusions, Hodari, Scalia stated in one section that for a seizure to occur, there must be either a submission to authority or a use of physical force. But in another part of the conclusion, it was said opposite of the definitive term according to the common definition of a seizure. So regarding the conclusion of Hodari, and even in Scalia's conclusion of Hodari, there were two different opinions on exactly what classifies as a seizure.
Okay. Right. We're over time, but thank you very much for the questions. We go back now petitioners for 5 minutes. I'll reset the clock. Okay, 5 minutes petitioners, begin whenever you're ready.
Physical impact must be intentional and must be designed to restrain movement, unlike County of Sacramento v. Lewis.
In Lewis, it was held that there was no seizure where the police officers accidentally struck a suspect thrown from a motorcycle during a high-speed pursuit. The respondent seized the petitioner by intentionally shooting her twice and objectively manifesting an intent to restrain her by stopping her from moving forwards, and the seizure only lasted the brief period of bullets impact.
The court must also consider what was said in Semira v. Municipal Court of City and County of San Francisco, that the basic purpose of the Fourth Amendment is to safeguard the privacy and security of individuals against arbitrary invasions by government officials. We pray that the court finds this fact pattern is sufficient to constitute a seizure by physical force, even if it wasn't successful. And if there is no more questions, we rest our case. Thank you.
Okay, very good. Thank you so much. Any other questions from the judges? No? All right, excellent. Thank you. Well, if the other team come back on the screen, please, and Mr. Steele as well. Let me first congratulate you. This was very hard. I think you all did very well. We asked you some really tough questions because we think you can handle it. You there, Semira? I think camera's still off. Okay. We asked you some really tough questions because we think you can handle it, and you handled it well. A couple things I think stood out that were important. I think you all had a good command of the cases. I think you all had a good command of your definitions of what a seizure is. And more importantly, you held your line. I tried to throw you off. I tried to ask you different hypotheticals to try and trip you, and you would not let me trip you up. You stuck to your guns, which was very hard. I think you also had good transitions. It's hard to transition in person, but you were able to transition with the person on your Zoom team who was in a different room, right? Far, far away. And that's not easy. So kudos to you. I really commend you. When I was 16 or 17 years old, I could not do this. So this is all extremely promising and really, really, really makes me proud. Curtis and Ryan, do you have some comments for our students?
Sure. I think you guys did a great job. Like I like Josh was saying, I would not have done this when I was your age because I've been too afraid. But you guys clearly did a lot of work for this. And like Josh was saying, you held your ground. And that's the key in an oral argument is you come up with a theory of your case and you stick to it. And when they challenge it, you explain it. And you did very good about not withering under questioning. And that's really hard to do for attorneys who are practicing law. So are any of you guys thinking of law school someday?
Yeah, I am.
Yeah? Yeah, are
Yes.
you thinking about any particular type of law or any particular law schools or?
I'm thinking about Texas Southern.
Oh, well, I teach the other law school in Houston. I teach at South Texas. And I emailed your teacher, Mr. Seal. If any of you are free this upcoming week, you're welcome to come visit my common law class on Zoom. It's a free pass, no cost, and you're welcome to see what law school class is like. If you're ever in Houston in the future, we're actually allowed to be in person again. Hopefully that happens soon. You're welcome to come sit in my class anytime, see what it's like. My law school is South Texas, about 5 minutes from TSU. We're very close.
Yeah, and if you have any questions about it, I mean, we'd be happy to answer by email or anything like that. We did law school and know what it's like. We can be brutally honest about anything you want to know, if you're thinking about that.
Curtis, any thoughts? By the way, Curtis is not an attorney. He's not even a college graduate. He's actually in college now. I think you're a freshman, right?
Right. Yeah.
Yeah, he actually did this tournament for us a couple of years ago and did very well. So I'm happy to invite back some of our graduates to do the judging. Any thoughts, Curtis?
Yeah, the quality of the competition has improved. I can see just judging a few rounds. This was a good round. You all did very well. I was impressed by your command of the material. There's a lot of moving parts in a case like this. A lot of precedent, a lot of originalist arguments, a lot of policy arguments. I thought you guys did a good job, balancing, okay, here are historical considerations, here are policy concerns, here's what the precedent says. I thought it was a quality argument overall, so very well done.
All right. Do you have any questions for us, things in your mind?
I wanted to thank both Mr. Herbert and Mr. Brown for spending their Sunday. We all have wonderful ways to spend it, and thank you very, very much. You guys are what make this competition valuable.
Thank you. I think Cora was about to ask a question, so someone jump up.
Oh no, I wasn't going to ask a question. I was going to say thank you for
That's very nice
listening to us.
Oh, our pleasure. Nothing else I'd rather be doing now.
Oh, it's very enjoyable. I really have enjoyed this competition because it's such a good experience. You guys have learned how to do a tremendous amount of research, communicate your thoughts. And even if you don't go to law school, those are really valuable skills in whatever job you have. And you guys are very effective communicators. It's really exciting to be part of it. So I'm glad you guys were willing to sign up for this competition. It's has to be intimidating, right? Are you guys just naturals at this, or was this scary at all?
Yeah, I was really nervous.
That's wonderful. Are there any other questions, things you want to ask about law, about the Supreme Court, or anything else?
Girls, I'm going to open my Zoom. If you guys want to join me for a debrief, we can do that for a few moments.
Okay, awesome, guys. Thank you so much.
All
We'll
of
be
you.
releasing the scores tomorrow, so you'll see them on Monday. But we're so excited to see what all the wonderful things you guys. You're going to do great things. I promise. You're going to do well. We will see you in the future. I don't know where, but we'll see you somewhere. All right. Take care, everyone. Bye-bye.
Bye.
Yeah,
Thank you.
And the students can sign off, and the coach and Ryan and Chris will go into the next step. All right. Let me turn off the recording.